Welcome back to another episode of NCBA's Coffee Break, where we dive into the legal and regulatory issues shaping our world one cup of coffee at a time. I'm your host, NCBA's VP of Government Affairs, Nathan Willner, and today I'm thrilled to be joined by someone who's been on the front lines of state level enforcement and consumer protection, Steve Hladik, partner at Hladik, Honorato and Fetterman, and former Deputy Attorney General for Pennsylvania's Bureau of Consumer Protection. Steve, welcome to our show.
Hey, thank you for having me. It's great to be here. I truly appreciate it.
Yeah, we're excited. So let's dive right in. So Steve, you've had a fascinating career path from managing the Harrisburg office of the Pennsylvania Bureau of Consumer Protection to now advising clients on mortgage, bankruptcy, and lending compliance. Um, and also, you're a member of NCBA, so we're happy to have you here giving us your background and expertise. So can you walk us through how your time as Deputy Attorney General shaped your approach to enforcement and compliance within your practice area today?
Yeah, again, thank you for having me. And that's a great question. I started out as a young attorney in the Pennsylvania Office of Attorney General, specifically within the Bureau of Consumer Protection. For those of you that don't know, state attorneys general are divided up into divisions, and it's pretty consistent across the states. And the vast majority of work that attorneys general do is actually civil work. A lot of people associate attorney general with criminal law, but only about 3 to 4% of the cases handled in Pennsylvania's attorney general's office are criminal. So it means the rest are civil. And they have an entire division devoted to what is called public protection. And those are things related to antitrust issues, charitable trust issues, utility issues for consumers. And they also have what's called the Bureau of Consumer Protection, charged with enforcing UDAP type laws to protect the citizens of the Commonwealth of Pennsylvania. And as a young attorney, you couldn't get any better experience out there on the front lines handling these things. Annually, Pennsylvania's Bureau of Consumer Protection handles over 30,000 consumer complaints a year. It's that many that go processed through. And what happens is you start to see patterns, or you start to see the same complaints or the same company names, and it begins to escalate its way out of a mediation process into an enforcement process. And that's where I came in, started doing a lot of smaller cases, but worked my way up to handling a lot of multi-state actions and actions that involve mortgage servicers, lenders, investors, and the like, doing them jointly with a lot of other state attorneys general. And that's one of the key things, especially in this day and age we're at right now. There's a perceived lack of federal enforcement at this point, and we are starting to see state attorneys general are going to step into what is a perceived void. So it's a very timely topic to revisit the types of UDAP actions and how state attorneys general work together on those kinds of enforcement issues.
Yeah, so I mean, as you mentioned, the CFPB up until about a year ago was the primary focus of people's concern when it comes to compliance and audits and enforcement, especially within the debt collection litigation practice, which many of NCBA's members are deeply involved in. But now there's been sort of a rollback on that with the current administration. So now the state attorney generals are kind of, especially in more, I guess, democratic states, moving in that direction, it seems. And so you've handled cases involving UDAP, FDCPA, RESPA, TILA, some of the most complex areas in consumer protection. So what are the common pitfalls you see companies falling into during state examinations or enforcement actions? And how can they better prepare themselves for this, maybe wave of enforcement?
Yeah, that's a very good question. And there is a stepped up review going on now. I can tell you all state attorneys general are taking a closer look. Yeah, as you know, most attorney generals are elected and consumers are their voters. So it's in their interest to assist their perceived voters. And what happens is, the first way you get on an attorney general radar is a consumer filing a complaint. And you would be surprised how many times when the AG gets that complaint, they send it out to the business for response. And you would be surprised how many businesses just ignore it. Say, we don't have to respond to the AG. That's probably the worst thing you can do. The biggest thing is just reply timely to them and give them the information. The people on the AG's office, there's a perception out there that they're always biased against the lender. That's not true. In that, if you present them their side of the facts, they realize that not every consumer is 100% truthful, not every consumer is 100% accurate, and not every consumer is 100% correct. And they're looking for you as the business. What is your point of view? What really happened here? And a lot of times it can just end right there. They say, okay, case closed. But it's when they start to see a pattern or practice, and there's certain things they're taking a hard look at now. You know, everyone wants to talk about junk fees. That's just an example. If there's fees tacked on when you're collecting a mortgage payment or a credit card payment, things along that line. If the AG starts to see a pattern of that, it's going to transition from a mediation of a consumer complaint into an investigatory stage. And at that point is where the state AG's powers really kick in. They have a phenomenally large ability to subpoena. Pennsylvania has a subpoena power. A lot of other states, they have what are called CIDs, civil investigative demands, just a fancy term for basically a subpoena. And this is also where state attorney generals come together to work together to share information on companies. It's not uncommon where Pennsylvania says, hey, I've got 50 complaints alleging the same thing against this particular lender. What do you have, Florida? And Florida says, hey, we have the same type of pattern of practice. And before you know it, it's going into a multi-state investigation, which from the complexity of that side responding as a business, it gets very difficult. So rule of thumb, always respond to the consumer complaint first. Try not to even get it open in the investigative stage. If you do, and you start getting requests for information, you know, the first thing you should do is actually talk to the deputy attorney general. See what he's looking for. See how you can limit the data that they're looking for. Can you limit the time frame? Pennsylvania also has a lot of important statutory protections that say information provided in response to a subpoena can't be used in an enforcement action against you. So you never want to waive, the protections that are afforded by that subpoena. There's little tactics or little techniques like that that businesses should be aware of. Every business sooner or later has a consumer complaint. It happens. So just being timely and responsive and working with them is probably one of the best things I can say to business.
And as I'm sure you agree that many times just having the conversation with the consumer resolves it in a way where it goes from an angry consumer who's already gone through the effort of filing a complaint with the AG's office to someone who's actually sending you a thank you note when you're finished, because all they really wanted was the person to talk to and explain why are they in this situation, and what can they do to resolve it. So they're complaining.
That's true. I tell you,
no
9 times out of 10, a business will bend over backwards, even if they're not forced to. They don't want an angry customer. They'll do what they can to make the customer happy.
Yeah, I mean, absolutely. And again, the uniqueness I think of this practice area of creditors' rights is that unfortunately, if a law firm or creditor makes a mistake, they tend to make it over and over and over again because it's that kind of practice. If you're sending a letter that an attorney general might not like the verbiage in, you send it 100 times. So now you have a much bigger problem. So it's really important to jump on these things quickly before they kind of take on a life of their own. And you
used the perfect phrase. What they're looking for is a pattern or practice of conduct, and applying that to the standards of UDAP. So that's what they're looking for.
Yeah. So given your role, first of all, I just found out that you have a role within the Legal League Advisory Council. So maybe you can tell our listeners what that is and what your ongoing work there is, and what kind of trends are you seeing from state attorney generals with their coordinated enforcement actions? Are there emerging specific areas of focus that the industry, both on the mortgage side and the credit card side, should be paying close attention to?
Again, excellent question. So the Legal League 100 is a trade organization devoted to the mortgage default servicing industry. So obviously there's a lot of you have mortgage defaults, bankruptcy, and things related to residential mortgages. That's the type of trade organization that is. I had the good fortune of serving as the chair of the Legal League for the last 4 years. And what we were actively involved in is assisting the mortgage servicing industry, because there's always proposed regulations. There's always enforcement. There's always pending cases. We've been involved on several levels for amicus briefs filing on behalf of the mortgage industry at various courts around the country. So it's an advocacy organization and a trade organization that always wants to maintain its relationships with borrowers, customers at the best level, but also seek compliance, but also seek reasonable compliance. When there's overreach by state regulators to try and get a voice of the industry in there to explain to a particular state why it's a little misplaced or misguided what they're seeking. Now, you mentioned what's happening on the multi-state level, and there is a lot going on right now. Like I mentioned earlier, there is that perceived void on the federal side. So state attorneys general are gearing up, and a lot of them are creating what are called mini CFPBs. Pennsylvania was actually the first one to create one. The mini CFPB is literally picture a CFPB unit, but housed within the Bureau of Consumer Protection or Public Protection Division within the state attorney's general office. And Pennsylvania has one, and it's being led by a former enforcement attorney from the CFPB. He's already brought some significant federal lawsuit in Philadelphia against a consumer lender. And what he's doing is the AG is privately enforcing the Dodd-Frank Act in that federal action. And there's a key opinion written by the federal judge in that case saying clearly that the state attorney general has the right to go enforce Dodd-Frank without the CFPB or federal government being a party to that case. So with that decision, you're going to see a lot more of these mini CFPBs turning up within states. You will see at some point a coordinated effort among state attorneys general, focusing on consumer protection, on borrowers, on how their accounts are handled. If it goes into foreclosure, why? Did you comply with all loss mitigation rules? Did you comply with, are you charging fees that aren't permitted under the mortgage or note? That's one of the easiest things. Are you passing along attorney's fees that you're not entitled to? These are all the avenues that they're going to be looking at.
Yeah, so basically, the gloves are off, the attorney generals from that perspective, and as you mentioned, their connection to the voters. There's a joke, but it's not so much a joke that
I know it.
that attorney generals are, are governors in waiting. That's really
Right,
their
well,
goal.
yeah, AG stands for aspiring governor.
And doesn't it? And and that's been shown to be true over and over again throughout the country. So, but which on the one hand, there's a political kind of perspective to the AG's office on from a high level, but because it's that, I think there's opportunities there. And what I notice, just like when dealing with advocacy and dealing with legislators, there's nothing wrong with reaching out to your attorney general, to the attorney general, and if you can't get to the attorney general, to their consumer protection division, get to know the assistant attorney general, who's really has a lot of control over your professional life. It makes a big difference, wouldn't you say? I mean, personal relationships have.
You're absolutely right. One of the first thing I tell clients is know your regulator. It cannot hurt to have a good relationship with that person on the other side of the table. And it can vary amongst AG's offices, but I will say in the vast majority of them, they are not out to crush or destroy a business. They want a consumer made whole. And if you can sit there and say, here's a pattern, we're sorry, we've already corrected it, we want to make our consumers whole. And a lot of times that'll resolve the issue without having to go down a costly, long litigation. So, that was my perspective when I was in the AG's office, was that, look, if something happened, fix it for the consumer and don't, make your internal controls so it doesn't happen again. So, that's the way I view it. Some offices are not of that view, but that was mine.
Sure. But I think also, depending on who it is and the personalities involved, you can make yourself a resource also, where not only will it, maybe help you with your own office's issues, but it also, you become like a resource where if the assistant AG has a question about, what a RESPA issue or an FDCPA issue, they'll say, hey, Steve knows, I'm going to give him a call, let's see what, and that is, and once you have a seat at the table, you really can make a difference. I mean, that's when you really have some influence, not only for yourself, but for the whole industry. So I think that's great advice. We're getting close.
Absolutely. And there's one other tip is that
Yeah, sure.
the AGs also, they have public pardon me, meetings open to the public twice a year where they talk about their enforcement agenda. And what's highest on their list? Protection of borrower privacy, cybersecurity, all those things related to borrowers and their personal information. And they announced that. That's what we're focusing on in the next 6 months.
Yeah. So we're getting close to the end of our cup of coffee, so to speak. And there's a lot here, a lot to unpack. And we didn't even get to the part where lawyers doing foreclosures are no different than lawyers doing debt collection. We're all debt collectors under the FDCPA, and there's all kinds of things there that I'd love to touch on with you in the future, like attorney-client privilege and confidentiality, and just because they're asking for some documents doesn't mean our law license allows us to give it to them. So there's lots of things to talk about. Yeah.
Sorry,
So,
I'm choking here.
yeah, no, I mean,
Choking on my coffee.
well, I know that this issue kind of gets everyone choked up, so we're all okay. Anyway, we're getting close to the end of our coffee break, and I just want to thank you and for joining us today. It's been incredibly insightful. Thanks for sharing your experience and helping us better understand the evolving landscape of state enforcement, because we surely have not heard the end of it. So thank you so much.
Hey, thank you. Truly a pleasure being here. I really appreciate the invitation.
Yeah, and we're going to hear more from you in the future. I'm hopeful. And thank you to our listeners for joining us for another episode of NCBA's Coffee Break. Until next time, stay informed, stay compliant, and I guess stay caffeinated as well. So thank you, everyone.